When it comes to employer-sponsored visas, I know we talk a lot about the requirements for the visa applicant, but what are the requirements for the employer? Now, depending on the occupation, there are certain caveats that do apply. However, the department will judge the business. And one of the things they judge is whether the employer genuinely requires that position within their business. So one of the really popular occupations for employer sponsorship is accountant, but accountant is a very tricky one. It's actually really hard for a lot of businesses to justify that they need a full-time accountant. If you're working in an accounting firm, then that would be fine. Of course you need accountants. But when it comes to other types of business, unless the business is really large and has a huge accounting department, a lot of the times these applications get knocked back. So say for example, if you're a smaller scale restaurant, you wouldn't be able to justify that you need an accountant. Whereas if you were an accountant working in the head office and the business owns a number of restaurants, then that would potentially work. But it's something to definitely keep in mind when you're looking for employer sponsorship. This is new for student visa applicants to Australia. The new rules require onshore student visa applicants to provide a certificate of enrolment at the time of application. Now, this previously was not required. If your application is submitted without the COE, it will come back as an invalid application. This has also been confirmed on the Department of Home Affairs website. 1,883 days. That's how long it was taking the AAT to finalize a review for a partner visa decision. If you had a visa refused in Australia and you don't agree with the decision, as long as you apply within the time frame, you can appeal the decision to the ART. Previously, it was called the AAT, but as of the 13th of October 2024, it's been changed to the ART. And they published some of the processing times for a case to be refused depending on the visa subclass. So for example, for student visa refusals, it was taking up to 757 days to finalize the case, which is crazy. Now that it's changed to the ART, they are hoping to finalize these decisions a lot quicker. Remember, if you do get a visa refusal and you don't agree with the decision, you can get advice from a migration agent or lawyer to appeal this decision because the member will look at new facts against the existing laws and policies.